the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration, be and is hereby issued that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated the seventh respondent right to a fair administrative action under Articles 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024 together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He further asserted that the Senate proceedings he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and that by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll proceed from paragraph 133. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characterized by low turnout in several constituencies and undertaken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate proceedings. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing despite His Excellency Gachagua's illness and hospitalization, and thereby denying him an adequate opportunity to personally defend himself. Further, the petitioners alleged bias and conflict of interest arising from participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Omolo, Senior Counsel, in the Senate proceedings, stating that their roles compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, they sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See, a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations rendering unconstitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and the violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditionally and constitutionally and unlawfully removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, declaration that the participation of Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings before the National Assembly and Senate violated Articles 10, 32, 47, 48, 50, 145, and 150 of the Constitution. He stated that the public participation process conducted on the 4th and 5th of October 2024 fell below the constitutional threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county officers instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation. and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marked by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gachagua stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachagua committed crimes under national law. Mr. Gachagua also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gachagua sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 30, under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process as against the first interested party undertaken by the first and the third respondents was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president by the National Assembly under Article 149 of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC at the time of nomination of Abraham Kithure Kindiki was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gikonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024, as well as on the 16th of May 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation under Articles 1 and 10, 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they meet constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first representant's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate, and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of the National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. It stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru ASK Show, and Tomorrow College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachagua was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is His Excellency Gachagua, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachagua and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as cuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and the public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a Deputy President from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a Deputy President who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190 sub-Article 1(b) of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular Deputy President could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of the National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagement through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection, but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergency points such as churches, mosques, temples, public barazas, national radio stations, vernacular broadcasting stations, and other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into two venues, and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagements, all of which demonstrated a failure to meet constitutional standards and called into question the validity of the impeachment of His Excellency Gachagua. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate. the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly, the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, adverse finding, to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Martial, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial right, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachagua fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and assessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others versus Kiruti Factory Company Limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachagua. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalist party where fairness and due process rights were under 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real and effective opportunity to participate, and included the right to attend and to answer the case one first, as well as the right to correct and contradict the allegations made against one. Further, that an adjournment was a recognized incident of a fair hearing where unavoidable circumstances prevented attendance or effective participation, and accordingly, the denial of a reasonable adjournment amounted to a denial of the right to be heard. The Senate could have proceeded in His Excellency Gachagua's absence if his conduct had made it impossible to continue the hearing, or if, after due notice, his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachagua's ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the relying on the Wambora case, Kituo cha Sheria recalled the Court of Appeals statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs whenever they applied or interpreted the Constitution or enacted, applied, or interpreted any law or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachagua's hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenyans' commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through replying affidavits sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members. That public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all three national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public and the public would submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondents further claimed that one of the petitioners, Honorable Jane Jerry Maina, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required two-thirds majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identify the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the constituted petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections, contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation, strict timelines, and bicameral supermajority representation requirements of the two-thirds in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate, that impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned counsel also cited the decision in the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if the discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, That is 2 days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They contended that impeachment is urgent as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Mbarak Issa Kombo's case. It was their further submission that public participation was adequate as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others versus Okoita and 52 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachagua's response was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender principle does not invalidate Parliament, as Articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity, and that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to resolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Subarticle 3A, mandates the Senate to convene and hear such charges. That Article 145, Subarticle 3B, uses the word may, and therefore the appointment of special committee was discretionary and not mandatory. And the semicolon and in Article 145, subarticle 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special committee on the 9th of October failed as it was not seconded, and the Senate then properly proceeded in plenary. They relied on the Supreme Court court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by committee, and that the same applies to the deputy president. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, subarticle 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforced accountability and good governance. It was their father's position that His Excellency Gachagua received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment unreasonably, as Senior Counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachagua, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday, 19th, October 2024, within the constitutional time frame, but this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachagua had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that representing a party in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. They further submitted that the Senate applied the correct standard of proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko and Wambora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachagua's own public admissions. Learned Counsel submitted and urged that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms Counsel gave comparative analysis of the U.S. Vice President